There, this is Dan Garrison with Fresh Start Funding.
And this is Matt Hartley, also with Fresh Start Funding.
I apologize for a slightly late start here. We had a few technological challenges. Zoom is very, very slow today. So feel free to let us know in the comment section if you're having problems picking things up. We will be recording this webinar. It'll be available to you later. We will also take questions at the end of the presentation. And so if you use the Q&A button at the bottom of the screen, you can go ahead and type in your question whenever it pops into your head so that you don't forget. And Matt and I will leave some time at the end of the presentation to go through your questions. Yep. So today's topic is how to ethically and legally increase your fees when you bifurcate Chapter 7 engagements. And for those of you who are kind of new to the practice, we'll walk through a little bit of that. But before we kind of get started, it might make sense to know just a little bit more about the two of us. So,
sure.
So Matt Hartley is an attorney with going on 30 years of practice. Started out in the big firm world for a long time, was in private lending for a period of time, and then ultimately several years ago, he started a consumer bankruptcy practice here in Arizona that he pretty quickly grew to be the largest in the state and one of the largest in the country. And actually his origin story about learning about bifurcation really is kind of the origin story of Fresh Start Funding as well. But Matt's very well regarded as an expert in consumer bankruptcy practice, and then over the last several years really has become one of the leading experts on bifurcation.
Well, thank you, Dan. I appreciate that. Dan's also been practicing maybe 1 year less than me, I think, when I last like checked. So Dan also came out of the big firm world, clerked for a federal judge, and then worked in some large firms. Spent most of his career doing bankruptcy, has litigated all across the country, has spoken across the country, has authored and co-authored many articles in the ABI Journal and other publications. So he's very well regarded for his expertise on bankruptcy as well. And Dan truly is probably is the #1 expert in the country on bifurcation. I'll fall in the #2 slot there, I guess.
If there's a difference, it is very small, and it's only because I've been involved in helping get this process approved in courts here and there across the country where questions have been raised, and we'll talk about that a little bit too.
Yeah, but I'll mimic a little bit what Dan said. So this is a pretty narrowly focused webinar. So we're talking about how you can legally and ethically raise your fees when you bifurcate a Chapter 7. If you're interested in the more broad questions of bifurcation and how it's done correctly and the case law and different things, we have lots of webinars available that address those issues. And we also have staff and ourselves who are happy to jump on a call and talk about these things too. So we have lots of information, but today is pretty focused, although focus on what I think is a very important topic and something we talk about all the time with attorneys across the country.
Yeah, and having said that, we will give you a quick overview of bifurcation and why this issue comes up in the context of bifurcation. So maybe it makes sense for us to kind of give you a little bit of an agenda or forecast of what we're going to do. So Matt, you want to kind of touch on where we're going to go today?
Yeah, so basically we're going to talk about the various statutes and rules that apply to your fees, because there's bankruptcy rules and code or statutes, as well as the ethical rules or rules of professional responsibility that apply. We're going to talk about the fact that many attorneys do in fact raise their fees when they bifurcated Chapter 7, and we'll talk about that in a lot more detail. And then the one thing I guess we want to make sure is clear is that if attorneys overcharge, they will get their fees disgorged. So you have to make sure if you're increasing your fees in a Chapter 7 bifurcated case that you're doing it correctly so that your fees will not be disgorged by the court.
So with that kind of lead in, maybe we do talk a little bit about bifurcation for those who are new to it. And so bifurcation is essentially the idea of splitting your engagement into two pieces that revolve around the petition date. And so it recognizes the reality of the way the work actually is done in a Chapter 7 case by having a separate engagement agreement pre-petition for the minimal work that's necessary to commence the case. And then once the petition's been filed, there's a separate engagement agreement that contemplates all the rest of the work that has to be done in a typical Chapter 7, as well as the things that might come up, don't always come up, which we'll talk quite a bit about today. And the notion is that by entering into a separate post-petition agreement, that contract, that engagement agreement is not subject to the automatic stay, and it's not subject to the discharge in the case. And so you've got a valid post-petition obligation, not unlike if the debtor went out and say bought a car the day after they filed a bankruptcy, that debt wouldn't be subject to the bankruptcy, and your post-petition engagement agreement is not either.
Yeah, and so the key to that is the fees you're collecting post-petition are for post-petition work that was performed pursuant to an agreement signed with the attorney post-petition. So it's all about everything happening post-petition.
Yeah, and we'll talk quite a bit about this in the context of reasonability of fees, that this can't simply be a pretext or pretense that allows you to try and collect post-petition installment payments on your fees. It really does need to reflect the reality of when you do the work, and it needs to fairly attribute fee value to that work, both pre and post petition. Now, there is a very common kind of variety of bifurcation that is really taken over a lot of markets in the country, and that is the zero down model, which is the idea that you do that minimal work that's necessary to start the bankruptcy case, and you waive your fees for doing that, so that the typical debtor that comes into your office for consultation and tells you that they're too broke to go bankrupt because they can't come up with fees or even a filing fee has an alternative.
Which is most of my clients, by the way.
Yeah, actually, there's a lot out there, and as Matt said, we've written about this and we've spoken about it, and you can take a look at those materials separately, but there's just a very big need out there for a solution for people that simply don't have a way to come up with money to pay an attorney fee or to pay a filing fee even before you start their case. And all of us have had to languish, with solutions that don't really do the job, like putting people on what we call layaway plans to pay for their bankruptcy, where their access to the relief, which is the thing they're looking for the most, is delayed or denied until they can get the fee paid. And they're trying to come up with the money while creditors are still chasing them, which makes no sense at all. Yep. So this provides a mechanism and a structure that's well recognized in the case law and has gotten quite a lot of national attention over the last couple of years, for you to be able to give the debtor what they're looking for most, which is relief as quickly as possible, while you still preserve the ability to charge a reasonable fee for the post-petition work and to make that engagement economically viable for you too. And in the process, we also reduce pro se filings and the burden on the court. So we talk about this as being the win-win-win.
Yep, I agree. So Dan, let's talk about, maybe talk first about the bankruptcy statutes and rules that apply to fees. I'm sure a lot of you attorneys are familiar with it. I think a lot of busy practitioners, especially in the consumer side, probably haven't read some of these rules in a long time.
Sure.
But we'll touch on a few of them just to make sure everybody's on the same page.
Yeah, so there is a beauty and a horror in the way that Chapter 7 debtors' attorneys are treated in the bankruptcy code. So the beauty side of it is that we're not estate professionals. We're not subject to applying to be approved by the court. We're not subject to the heightened disinterestedness standard that, say, a Chapter 11 debtors' attorney would be. But the horror of it is that, as a consequence, our fees aren't considered an administrative expense of the bankruptcy estate. We're not subject to 503. We don't have to file applications under Section 330. But what the code does instead is it imposes Section 329 on us as bankruptcy attorneys. And 329 says that Chapter 7 debtors' attorneys' fees still need to be reasonable. And it provides that if the compensation exceeds the reasonable value of the services, then the court can cancel the agreement or order the return of the payment to the extent that it's determined to be excessive. That's the fundamental bankruptcy code provision that applies to reasonability of attorneys' fees in a Chapter 7 consumer case. Now,
and what's interesting to me is that it's literally that simple. I mean, it's just that simple statement in Section 329, but there's been a lot of litigation, as you can imagine, over the decades dealing with it. But it is such a simple provision at the end of the day.
So there are two provisions that basically implement Section 329. The first is Bankruptcy Rule 2016B. And 2016B requires you to make a disclosure that's required in Code Section 329A, that 329A says requires you to disclose the amount of compensation that the debtors agreed to pay and the source of the compensation. And that's all it requires. 2016B, in turn, says that you have to make the disclosure that's required by Section 329. In addition, Rule 2017 also talks about the fact that different parties at different points in the case have standing to review or even challenge the reasonability of fees in a bankruptcy case. So 2017A says that where you're talking about pre-petition transfers of compensation, any party in interest in a bankruptcy has a right to challenge that. Section 2017B, or Rule 2017B rather, talks about the fact that for post-petition transfers of property or payments of compensation, that the court, the debtor, or the United States trustee has the standing to assert, that there's a reasonability challenge. That is really the entire contour of how the bankruptcy code and the bankruptcy rules govern reasonability. Now, there's also a form, as you all know, that's required to be filed that implements the disclosure. And the national form is a director's form called B2030. There are sometimes local variants of that that are imposed, by your local rules as well.
Yeah, I guess the other thing we should add too is with regards to fees, there are also sometimes local rules too that deal with fees. And the primary thing I think is really that sometimes there's what they call a no-look fee, and no-look fees are very common in Chapter 13s, and they're pretty rare in Chapter 7s though, but some states definitely have them. And they set a maximum amount that basically will be deemed acceptable, as long as you're under that amount. So you should make sure in your local jurisdiction that you find out whether or not there's a local rule like that, and make sure you understand that as well.
Yeah, and sometimes those no-look provisions which exist are tied to another type of rule called limited scope representation rule. Sometimes there's a rights and responsibilities agreement that has to be filled out that specifies the services that have to be provided in the Chapter 7. That's going to end up being relevant to our discussion of how you determine the reasonable value of the work. So we'll touch on that in a little more detail later in the presentation.
Yeah, so maybe it'd be helpful, maybe get into our PowerPoint, we can put some of these,
so
we can move to the
I forgot we had a PowerPoint.
rules of professional conduct.
And this is where Zoom's being kind of slow, so bear with us a little bit if this is a little bit slow showing up. Okay, so here we've got 329 and rules 2016B and 2017B that we talked about.
And so now we're going to talk about the rules of professional conduct, because these are also important. As many of you know, the bankruptcy rules incorporate the rules of professional conduct. So, I mean, by kind of common sense, they apply to you no matter what when you practice in the state, but it also gives the judge the ability in a bankruptcy case to enforce them as well. So the most direct rule on fees is Rule 1.5a, and this is the model rule published by the ABA, and this has been adopted almost verbatim by most states. There may be some nuances out there that I'm not aware of, but most states have adopted all the model rules, and 1.5a is one of those ones that we haven't really seen much change in from different states. But it's very straightforward. I'll just read it. It says a lawyer shall not make an agreement for, charge, or collect an unreasonable fee or an unreasonable amount of expenses. The factors to be considered in determining the reasonableness of a fee include the following. And we'll go through this list. I won't read all these, but it's the number one is really the most important. It's the time and labor required that the attorney performs in the case. And some of these aren't going to really apply, but there's likelihood that doing or accepting the job, the lawyers be precluded from taking other work. They also look at the fees customarily charged in your locality. And to me, that's a super interesting rule because as we all know, in all kinds of different areas of practice, there are just vastly different fees that attorneys charge. You could have one attorney charging $200 an hour and another one charging $800 an hour. And, presumably the $800 an hour attorney is better, but that's not always the case. So to me, it's always been an interesting piece of the rule for courts to apply. And then of course, sometimes the amount involved or results obtained. So if someone's trying to discharge $5,000 of debt, you wouldn't want to charge them $50,000 for the work. That obviously would not make any sense.
Well, likewise, if you have a case with a business exception that has $500,000 worth of debt, it probably is, a case where you can charge a higher fee than a standard below median, no asset case. So works both directions. And then the any time limitations imposed by the client, and that's important in bifurcated cases because oftentimes, or really any bankruptcy case, almost you're almost always filing them quickly because whatever's going on in the debtor's world is just getting worse with time, and so typically we are pushed to get these cases filed quickly. And then obviously any relationship you have with the client comes into effect. And then of course the attorney's experience and reputation. And then of course, whether the fee is fixed or contingent. And obviously contingent fees don't really apply. So there's a whole host of factors that get taken into consideration by courts when they're looking at whether or not the fees are unreasonable under the rules of professional conduct. But as we talk a little bit later, the rules are really pretty consistent. We're going to talk a little bit about the Lodestar analysis as well, but you combine Lodestar and the bankruptcy statutes and rules, they're very similar.
I guess the last thing I have, there is an ABA comment to the rule. It just talks about, they require the lawyers to charge fees that are reasonable in other circumstances. And then, the factors 1 through 8 aren't exclusive. So there could be other factors taken into account. The courts can ignore some of the factors. So it's very broad, I guess, when I look at this as to what is the most important thing. But we'll talk, I think Lodestar really nails this at the end. And this also talks about, passing on expenses. So that's the main rule. There's other rules that we'll talk more generally about, like making sure, the agreement you have with your client is in their best interest, and the fees you're charging, making sure they're overall reasonable as well as being in their best interest. So, but Dan, why don't you actually talk about the other big factor in this is Lodestar.
Yeah, so, and not surprisingly, the standard that gets employed in bankruptcy courts and in bankruptcy cases does parallel in a lot of different ways the ethical rules test as well. And this is one of the few things about which there's absolute certainty. In every circuit in the country, the fundamental test for reasonableness of fees under Section 329 is what's called the Lodestar Test. And Lodestar really refers to the basic calculation that it imposes. And it is the notion that the reasonableness of a contingent or a fixed fee is determined with reference to a number of hours times an hourly rate. And so let me kind of expand on that a little bit. Fundamentally, what the Lodestar Test says is that a court needs to look out into the market and figure out what a reasonable market hourly rate is, and then figure out what a reasonable period of time to complete the services would be, and multiply those two things together. And that becomes the presumptive Lodestar value of the services that were performed. And it becomes the baseline against which the court can then compare a fixed fee or a contingent fee to determine whether it's reasonable. Now, the Supreme Court's been very clear on this. In the Purdue versus Kenny case, they came out and said that they strongly support the imposition of the Lodestar standard because it provides certainty and predictability. And they use the term that it cabins the discretion of the trial judge. In other words, it imposes a standard that makes these things predictable and uniform across the country, but still tailored to the particular location that you're in. And so, for example, the Lodestar test clearly contemplates that a reasonable market hourly rate in eastern Idaho will be different than it will be in the Southern District of New York or something like that. So it takes into account, sort of the variation that exists across the country from market to market. And then it also, tries to moderate, if you will, the practice approach the different attorneys take by saying that you need to kind of figure out what a reasonable period of time is to complete the services. And that obviously is going to vary from case to case, depending on the complexity and the number of things that pop up that perhaps you didn't count on. Yep. Now, the Lodestar test has steadily been distilled down to a very strong preference for just the hourly rate times the number of hours. But historically, Lodestar analysis has taken into consideration a lot of other factors too. So for example, the fact that the issues might be novel or complex versus pretty standard, the fact that there might be a particular longstanding relationship with a client, the market kind of barometer of what's reasonable for different things. But the Supreme Court has steadily kind of narrowed this down to a presumption that your baseline really is the surest test of what's reasonable, and that's the number of hours times a reasonable hourly rate.
Yep. So the other issue we want to talk about too is that, so in Consumer Chapter 7s, almost all attorneys charge a flat fee. And the fees though they're lower than what they should be if you apply to Lodestar analysis. So, if you take into account, the hours and time that an attorney and their staff put into a case, and you compare that to how much they're charging, the attorneys are almost always undercharging in Chapter 7s. And so, and we'll talk a lot more about that in detail, but it's important to understand, and I guess part of this is based on, assumptions maybe on our part, but some facts you can't ignore. And there actually have been some studies on this, but, part of it is that the Chapter 7 consumer services become very commoditized. Yeah. Especially from a consumer standpoint, they don't really see a difference between you and then the person down the street who just graduated last week from law school. they just see, I need to file bankruptcy, I need to pay a price, so they're happy to, God, I can save $100. Yeah, this person's been doing it for 20 years, but this person's can save me $100. So they'll go down to the other attorney, and it really affects how flat fees are valued and how they're charged in a Chapter 7.
Well, and truly, we don't have a fair market for traditional Chapter 7 fees. And the reason we don't is that debtors are forced to come up with the full fee for all of the work and to prepay it before the work is done at the point in time that they're in probably their highest, state of financial distress. And attorneys, on the other hand, need to come up with a flat fee that debtors can afford to prepay. And so it puts artificial pressure on both sides of the transaction that really doesn't yield a fair market value. And a fair market value is defined as the price that a willing buyer and a willing seller are willing to settle on without any sort of outside constraints or duress. And the system that we have around traditional prepaid Chapter 7 fees really have duress and constraints on both sides of the equation, which contributes to this commoditization that Matt was talking about. Simple fact is debtors can't afford to pay pre-petition.
Yeah, what's interesting too, you talk to attorneys who've been doing this for a long time, and most of them have not raised their fees in the last 10 or 20 years, and even more shockingly, a lot of them have dropped their fees that they charge for Chapter 7. Yeah. So it's a very unique area, because in all other areas, lawyers have increased their fees that they charge for nearly any kind of service that they provide.
Yeah, so we're not going to go through the whole origin story with you, Fresh Start Funding, but really the way Matt discovered it was, after the boom cycle following the Great Recession started drying up and filing started dropping, everybody steadily started decreasing their flat fee prices in order to try and attract clients. And Matt had been the biggest filer for quite a while, and suddenly there was a competitor that was filing more cases than he did in a particular month, and he thought, oh, goodness, they lowered the rates again. Yeah. I'm going to have to knock mine down too. Got on the docket and realized that they not only hadn't lowered their rates, they'd actually increased them, and it's because they'd started bifurcating. And it just goes to show the power of this when you offer the ability for a debtor to make manageable post-petition payments. Suddenly those constraints that we were talking about are gone.
Yep. So let's pull up we have a tool that we're going to share with everybody. We call it our fee calculator, but it helps drive home, I guess, both the complexities and the challenges with setting a fee in a flat fee Chapter 7. And once Zoom catches up here, we can show you some more stuff here. But I think the first most important thing is that we've broken out the services in Chapter 7 into 3 different buckets. So this form actually for traditional, so I should say there's 2 buckets here. When you bifurcate, there's 3 buckets, but here there's really 2 buckets. There's the first services are services that you have to provide in every Chapter 7. And here's the one with the 3 buckets. So this in a bifurcation, you have 3. So you have pre-petition work, the work that has to be done before you can file a case. Then we have the post-petition work that you're not going to perform until after the case has been filed. And then the 3rd bucket is the additional work that may come up in a case. And so you've already agreed to provide these services, and you may or may not have been paid for them. And so, and there's some weird local rules we'll talk about, but whenever you do a Chapter 7, you don't know if there's going to be a 2004 exam. You don't know if there might be a continued 341. You may or may not know if they're going to reaffirm a debt. There's a lot of things that could come up, but once you're in the case, you're in the case. And so, it wouldn't necessarily be fair to charge a debtor for everything that might possibly come up, knowing a lot of it probably won't come up. But at the same time, you're entitled to something for taking the risk that the case might end up being more complicated than you expected. And the thing is, since I never practiced in a jurisdiction like this, one of the things that always seemed crazy to me is that in some places you're even committing to represent debtors through a full adversary if it comes up in the case. Yeah. In most places you can exclude adversaries from your flat fees, at least, so you can get paid if they come up. But there are jurisdictions where if you file a case, doesn't matter how messy that adversary might be, you're going to, if it comes up, you have to represent the debtor for it, and you can't charge more fees in many cases.
So basically the approach that these two calculators take is that they have you put in an hourly rate that's typical in your market for your time, and then if you're using a paralegal or a legal assistant, for their time as well. And this goes to that Lodestar test that we talked about. That what this attempts to do is it attempts to quantify the value of the services that you will absolutely provide in every case. And then it also tries to handicap the value essentially of the services that you may have to provide, as Matt was saying, but don't always come up in every case. Yeah. And the conventional Chapter 7 fee calculator that we have here up on the screen right now, it takes the pre-petition and post-petition work and it just puts them into a single bucket. So this is everything that you would do pre and post-petition in a Chapter 7 engagement where you're prepaid for your fee. But what it does is tries to put a Lodestar value on that and then add to it the value of the things that you might have to do in any given case.
Yeah, and so we've made the assumption here too that paralegals involved. Not all attorneys use paralegals, but assumes that the attorney will be working on it and a paralegal will be working on it, and it makes obviously assumptions about how much time is spent. I mean, the task should be pretty uniform no matter where you practice, but the time spent could change, and also for this we assume the attorney charges $250 an hour and charges $120 an hour for their paralegal. And obviously those numbers vary a lot around the country. But the main point of this is that if you look at this, based on this analysis, it shows that a reasonable fee would be about $2,000 for a Chapter 7, ignoring the additional work that may come up. But just the basic work based on this amount of time for attorney and their paralegal, it's almost $2,000. And for most attorneys who are not bifurcating, they're not charging $2,000. And many attorneys are charging a lot more than $250 an hour.
Yeah. So it's interesting. We have these conversations with attorneys across the country all the time. And, a given attorney, Jane Doe in Illinois, will tell us that she charges $1,100 for a Chapter 7 case. And we'll ask, well, are you doing other non-flat fee work in bankruptcy, or are you doing other consumer law work? And she'll say, oh yeah, no, I'm doing some domestic work, and I occasionally will handle contested matters or adversary proceedings for clients. And we'll say, well, what's your rack rate for doing that? And she'll say, well, it's $250 an hour, or perhaps $300 an hour. And what do you charge for your paralegal? Well, I charge $100, $120, $150. And we reverse engineer this exercise and say, okay, let's figure out what your effective hourly rate is for that Chapter 7 work that you're doing for $1,100. And it's not unusual for us to discover that she's effectively getting $100 an hour for doing Chapter 7 work, where she's very regularly charging and getting paid and having courts approve $250 or more an hour for other consumer work and even other bankruptcy work. So this exercise kind of runs in both directions. And we should tell you as well that as a thank you for attending the webinar today, we're going to make these fee calculators available to you for download. And they are, as you could probably see from the screen, just Excel worksheets. Mm-hmm. And so you can go in and you can tweak the amount of time that we sort of forecast is typically spent on different tasks. You can put in your own hourly rate and play around with it and actually see in your own practice what would be a defensible Lodestar kind of value for your Chapter 7 work.
Yeah, but let's talk a little bit too, though. This does have in here the additional work we talked about as well. Right. And so again, on this one, this would give you an argument that a roughly $2,000 fee would be acceptable for the work you have to do in a Chapter 7. But we also believe that you can charge something for the additional work that could come up in the case. And so, but in a lot of cases, though, attorneys will just have some agreement that will charge extra money for that, and you can do that too. It's strictly in the bifurcated side of things, but in a regular Chapter 7 case, you can charge more money for those fees in most jurisdictions. But as you can see here, it's really quite a bit of work that could come up in the case. And again, if you're trying to flat fee and just get it all covered so there's no surprises for your client, you do need to charge something for that.
Yeah, and Chapter 7 attorneys and their clients, and frankly, even judges and trustees, appreciate the simplicity of a pure flat rate kind of approach to Chapter 7 because it provides certainty. No one wants to hear, the debtor's surprise and frustration at, finding out that they're going to have to pay something extra for something unanticipated that came up in their Chapter 7 case. And so most Chapter 7 debtors' attorneys really strongly gravitate towards a model where they say, I'm going to charge you X, and let's say it's $2,000, and I'll get some easy cases, and in which case I'll be doing really well on them, and I'll get some really complicated cases, in which case I'm going to be effectively doing some very low paid or free work in them.
Had those.
But they take the good and the bad, and they just dollar cost average it. The difference between a principled approach to this, which is the Lodestar analysis, and what happens in a typical market is, in a typical market, somebody goes, my competitor's charging $1,100. I can't afford to charge any more than $1,100, and I'm just going to be stuck doing what I do in the case. And, actually looking at the value of your work, a much higher fee may be defensible. And then once you layer in bifurcation and the idea that you can offer payment terms to your clients, then the clients no longer have an objection to that either. In fact, they're grateful for the fact that they can start making some modest monthly payments, and through our program can get credit reporting and things like that as well, versus trying to come up with the flat rate fee.
Yeah, so now we'll pull up the spreadsheet on Bifurcate Chapter 7, because one of the main things we're talking about is how you raise your fees and how you can justify raising your fees if you bifurcate a Chapter 7. So again, this one breaks the work into three categories: the pre-petition work, the typical post-petition work, and then the additional post-petition work that might come up. So as was mentioned earlier, on the pre-petition work, most people that bifurcate cases charge nothing up front. And so to do that, you're waiving your fees for that work. So in this one, it's my glass on is roughly $860, I think, in pre-petition work that's showing up. But if it's a zero down, you've waived that. So you're not moving that work to the post-petition to try to collect it post-petition. It's gone. And to collect it, you'd be violating the automatic stay. And so I guess I should also add, this is also why typically in bifurcated cases, you're trying to push as much work post-petition as you can. And so typically the statements and schedules are all performed post-petition. So you file what's called either emergency or rush or skeleton case. So you're filing just the bare bone documents that are required under the code to start a case, and you do as much work later as you can. But I always want to clarify, it doesn't mean you're not doing your due diligence up front. You're still going to do your due diligence. You're still going to be looking for prior filings of bankruptcies and preference payments and how to protect assets. You still do all the work you need to do to make sure the case is ready to be filed. You're just not preparing the statements and schedules until after the case is
So
filed.
the attorneys who do this the right way, and believe me, we can all point to cases where attorneys have not done this the right way and have gotten into some hot water over it, but the attorneys who do this the right way, they're still asking for documents from the debtor. They're typically pulling credit, and they are looking for those landmines in the case before they ever file the petition, so that they can comply really with BAP-CIPA's requirement that you're certifying that you've conducted an adequate investigation into the truth and completeness of what you're filing, and also so that you can do a good, competent job for your client under the ethical rules of making sure that they qualify, that it's in their best interest to file bankruptcy, that the chapter you're filing is also in their best interest, and that you've advised them, and to the extent that you can, worked around any sort of landmine issues that might exist in the case.
Yeah. So in this example here, so you're waiving those pre-petition fees, but you're still coming up with an over $2,000 fee for post-petition work. And the reason for that is bifurcation is more work. At a minimum, you're going to have a second signing appointment with your client. And as you all know, except for with some exceptions, when they come in for that second signing and they review those statements and schedules, they're going to ask you all the same questions they asked you before. Yeah, I mean, if you can do that in an hour, then you're doing great. But there's extra work, and there's also extra work for your staff, assuming you have a staff person filing the case. I mean, it's always a little more pain to file the statements and schedules later after the case has already been filed. So there's just some extra work that happens in a bifurcated case.
So, Matt, one of the questions or challenges that comes up sometimes in reasonability on that very topic is the idea that folks will say, well, why would you unnecessarily complicate the process or duplicate tasks simply to protect your ability to collect fees? And that really ignores the fundamental nature of this, and that is that you're dealing with a client here who can't afford to come up with a prepaid fee and that needs a solution in order to get relief quickly. And so would it be more efficient to do the schedules and statements pre-petition and combine that with your diligence? Yes, absolutely it would. But in order to be able to offer a solution to the client who needs this and to be able to protect yourself to collect fees so that it's economically viable for you to represent that client, you put this structure in place that requires you to do diligence pre-petition to tick off that box and advise the client competently, and then you're pushing the work of actually doing the schedules and statements post-petition. And the fact is that the rules actually contemplate that you can do this.
Yep.
So Rule 1007 says that there are 5 things that you have to file with the petition in order to have an effective filing. And it doesn't include the schedules of assets and liabilities, or the statement of financial affairs, or even the disclosure of compensation. Those things by rule are allowed to be filed up to 14 days after the case is filed, and could be even longer than that, with the court's permission.
Yep. And that's important because we have heard arguments or even questions from attorneys and sometimes arguments from trustees that this wasn't a real emergency case. You had to file everything at once. But Dan's 100% correct. That's not what the code says. The code says it's so clear what's required to start a case and how many days you have to file everything else. So there's really no question on that.
Yeah, and it's interesting that they make these arguments that you need some sort of special circumstance or exigency to file a case this way, because the code allows what it allows and the rules allow what they allow. And there's nothing in the code or the rules that requires there to be some sort of an emergency for the basic provisions of Rule 1007 to apply. And they allow you to file schedules and statements after the case is filed. So that is, I want to highlight this, because we looked at the traditional fee calculator and the total value of all the services was about $2,000. And this obviously puts a much higher value on the fees than that. And at least part of that reason is that you are splitting your diligence in the preparation of the schedules and statements into pre and post petition buckets. And then there is some additional work that goes on post petition in a typical bifurcated case that is going to require some more time. And I would also tell you that you are comparing apples to oranges in a way when you compare a traditional prepaid case to a bifurcated case, because you are taking on the risk of non-payment. There's a time value of money factor that ought to be considered. And the ethical rules and the Lodestar Test all contemplate that those factors can allow a differentiation. So the example I use all the time is that just because you choose to do a very low cost filing or a pro bono filing for someone doesn't mean that that sets the limit on what is reasonable for you to file cases. You have discretion up to a cap that the court determines for what is reasonable to charge for a Chapter 7 case. So the mere fact that you've been filing them for a lower price traditionally, or other people in your market do, doesn't establish the ceiling of what's reasonable in your district. The only thing that typically does that in black and white is if there is a no-look fee, and that's not even a ceiling. That's just a threshold above which you're going to have to justify yourself, and below which you can, kind of skate through the system.
Yeah. So again, in this example, we have, post-petition work, $2,200. The additional work, if you scroll down to that, that's a lot more. But I want to make it clear, we are not suggesting at all that you would charge the max amount in your cases. I mean, this is a Lodestar analysis. This is a guide. Luckily, most attorneys tend to charge more than $250 an hour. So if you are charging $300 or $350 an hour, it'll give you an even higher number. But most attorneys, if they could justify a higher number, you're probably not going to want to go and charge $4,000 for bifurcated Chapter 7 unless you happen to be just in a really wealthy area, because that would be a very high fee, and I think it would be hard to justify even if the Lodestar, you could justify it. Yeah,
and that said, we have attorneys in Hawaii, in Southern California, in urban areas of New York and the northeastern seaboard that the rack rates, the hourly rates for the work out there is significantly higher. I mean, they're regularly charging $400 or $450 an hour. And so again, this exercise will demonstrate the maximum amount that you could argue is reasonable. But then what most attorneys do with this is they look at it and say, okay, taking that into consideration, I'm going to set my fee at this particular amount. And in this exercise, maybe it's $2,200 or $2,400. But this exercise not only gives you peace of mind that what you're doing is defensible, but going through this exercise before you decide to set your fee in a bifurcated case is a powerful piece of evidence should a trustee, the United States trustee, ever ask a question about how you determined the fee, because you can actually provide them with the exercise that you went through and say, look, before I ever talked to a client, I sat down and gave a really thoughtful, analysis to, what would be a reasonable fee. And here's the exercise.
Yeah, and I guess the last thing, kind of along the old, pigs get fat and hogs get slaughtered. I mean, my approach in my practice was always I wanted to be, as near the top as I could get, but I didn't want to be the most expensive person, because they get the, the most attention from the trustees and the judges if they're charging the most. I never wanted to be that person. I wanted to, get a reasonable fee. Because no matter what I charge, always seemed like it was less than what I could have justified under Lodestar. But I still wanted to be, towards the high end, but not the highest by any means.
Well, the other thing that happens when attorneys start to bifurcate a lot of times is they do feel liberated from that commoditization that we were talking about, and they realize that the clients that they're talking to are more than happy to, pay $100 twice a month or something like that for 12 months to pay the attorney fee. And so they immediately jump from a very low flat rate to a very high flat rate. And you can imagine that that just draws unwelcome attention from panel trustees, from the United States trustee, and potentially from the court too. So Matt's comment about pigs getting fat and hogs getting slaughtered, although we say that sort of tongue in cheek, is still a very important consideration that, just because you can charge a particular amount doesn't necessarily mean that you should. And it certainly doesn't mean that you should suddenly jump from, one very low number to another very high number. And we can tell you anecdotally that some of the attorneys over the last few years who have gotten some unwelcome attention have done just that. They've gone from $1,000 to $3,000 overnight or something like that. Yeah. And one of them in particular in Southern California, as Matt said, probably could defend a $3,000 rate based on the Lodestar analysis. But that jump just sort of shocks the trustees and the judges. And particularly where they weren't well defended and hadn't thought things through, that factor ended up being a big problem for them.
Yeah, and so really our next topic is to talk about some of the arguments that we see trustees or judges make about fees. And one thing it seems just sort of natural to do is to compare what you charge in a regular case to what you charge in a bifurcated case, or maybe what you charged a few months ago before you started bifurcating to what you're charging now. We hear that argument all the time, but it's actually, that's not the legal standard. It is the Lodestar analysis. It's so well accepted as the basis for determining fees in federal cases, including bankruptcy cases. And again, it's primarily a reasonable hourly rate times the amount of time spent on the case. If you gave somebody a discount or charged a lot less to something else, it does not matter. It's really is the fee reasonable that you're charging in that case?
And this is one of maybe three arguments that get made in bifurcated cases when they do come up, on the radar screen for the United States Trustee's Office. And so being prepared to explain this in terms of the Lodestar value and being able to demonstrate that you gave a very thoughtful kind of analysis to this before you set your fees ends up being immensely powerful in these conversations. And I can tell you that while we've certainly gone in and actually defended some attorneys against the motions here and there, we've had a lot more just inquiries from the U.S. Trustee's Office about what an attorney's doing when they bifurcate or how they set their fees. Yeah. And by and large, when we send them the exercise that the attorney has done and explain how they set the fees and how they're structuring the prepaid engagements, as a alternative, an option that everybody has, that those inquiries just don't go anywhere.
Yep.
They just quietly disappear.
Yeah, and so another important piece to consider in this, and this is another argument that we hear, but it is a valid argument, is that the fee structure needs to be in the best interest of your clients. And so sometimes the trustees will argue that, well, this is really just for the benefit of the lawyers, so they could get paid. It wasn't in the best interest of the debtor. And so the best way to defend that is always give your client two options. Mm-hmm. So if you have a lower prepaid rate and a higher bifurcated rate that allows them to make payments for 12 months after the case is filed, and you get other benefits we provide if you're working with us, such as credit reporting, give your client the two options and let them decide. In fact, the form fee agreements that we provide to attorneys contemplate exactly that. It gives it very clear two options to debtors so they can be fully informed and they can make the right decision that's in their best interest. They can see, if I pay before I file, it's going to cost me this. If I get filed with paying nothing down, but I'm going to make payments afterwards, it's this. it's going to cost me this much more to do it that way. My payment's going to be this much per month. It gives them all the information they need so that they can make a decision. And that just stops the argument that somehow it's not in the best interest of a client to pay a higher fee in a bifurcated case.
You know, a variation of this argument just seems kind of nonsensical to me as well. And that is, you know, trustees will sometimes say, well, the whole purpose of a bankruptcy is a fresh start, and yet you're saddling them with debt and a payment for 12 months after they file. And what that ignores is the reality that these folks are going to have to come up with the entire attorney fee if you insist on a traditional engagement, and they're going to have to come up with it while they're still fighting off all their dischargeable debt, their creditors. And, you know, that many of them, in fact, the studies would indicate most of them are languishing outside of bankruptcy longer than ever right now, and at great personal, familial, societal costs. And so, you know, the idea that making easy installments after they've gotten the stay and the discharge is somehow less in their interest than languishing outside of bankruptcy, trying to come up with the money to pay an attorney really seems wrong-headed to me. If anything, you know, if you look at this from a conflict perspective, there's always tension between an attorney and a client over payment of the fee. That's just inherent to the business of being an attorney. But it strikes me that insisting that they continue to languish in debt and in a lot of stress and denying them the relief that they're looking for simply so that you can get your fee paid really presents a much starker kind of contrast or conflict in my mind than providing them a solution, even if it is at a modestly higher cost to make payments over time after the bankruptcy is filed.
Yeah. And now the other argument we hear sometimes from trustees is that all the attorneys just trying to pass on the cost of financing to the debtor. And you know, I try not to make this my response, but sometimes my response is, you know, duh. I mean, you can pass on any costs that you incur as long as they're reasonable costs and your overall fee is still reasonable under the Lodestar analysis. You absolutely can pass that through. And Dan, I guess you can reference the
So
you
know, there's an American Bar Association ethics committee. It's number 484 that was released a few years ago that confronted this issue pretty directly and said explicitly, an attorney can pass on an out-of-pocket financing cost to a client as long as they have the client's informed consent and as long as the overall fee, including the finance charge, continues to be reasonable under the ethical rules. And so when we confront this particular argument, we really come at it two different directions. We say, first of all, look, the focus needs to be on whether the overall amount that's charged is reasonable. That's how Rule 1.5 works of the ethical rules, and it's also how the Lodestar analysis works. But even if you look at it in terms of passing on an out-of-pocket cost for the financing that we provide to your client, which effectively is what most attorneys do here, they look to just get to the same place, whether they bifurcate or whether they collect up front. The fact is that practice is okay ethically, and it's completely defensible. It just needs to be done with informed consent, and the overall fee needs to remain reasonable with the finance charge included. So we kind of come full circle back to the Lodestar analysis and the exercise. And so if it turns out, you know, that you charge one fee for a prepaid engagement and you charge a second fee for a bifurcated engagement, and the difference between the two is the expense or the charge that you pay to a third-party financing company like us to help you with cash flow and payment management and credit reporting, that's okay, as long as it's been disclosed adequately and the client understands the choice that they're making.
Yep. So I think we're ready for the Q&A. So it looks like we have some questions teed up here.
Yeah, it looks like we have several of them. And here again, Zoom's being kind of slow, so be patient with us here, trying to get them up.
It says, Dan, can you swing by and pick up some milk on the way home? Oh, wait, no, that's not the right question.
So what is the current total fee for Chapter 7? What is the no-look fee? Well, so William asked that question, and it varies from district to district. So I would say the majority of the districts do not have a no-look fee for Chapter 7s. They typically have them for Chapter 13s. And so the ones that do, they'll be a product of your local rules, and it will be very explicit. So for example, I just was looking at the Western District of Missouri, which is where Kansas City is at, and they have a $3,600 no-look fee for Chapter 7s, but the trade-off is that their limited scope representation rule and the rights and responsibilities agreement is at the highest level of anybody in the country. They literally have to do everything other than adversary proceedings, and then they can only accept those if they have an explicit agreement from the client. Otherwise, they're expected to handle everything, even non-dischargeability defense and that sort of thing.
Yep.
So William, take a look at your local rules, and depending on where you're at, there may or may not actually be a no-look fee. The reasonability of your fee, if there's not a no-look, even if there is a no-look, it ought to be a product of doing the analysis and downloading our fee calculator to take a look at that.
Yeah.
William also asks, how has COVID-19 changed the time spent since most matters are now being handled remotely? That's actually a great and timely question. Matt, you want to riff on that a little bit?
Yeah, actually, I wish I would have asked some attorneys how they feel about that. Because I could see if you're doing it very efficiently, it might actually save you some time. But I think overall it's probably increasing time because it's just a different environment when you're dealing with people by video and you have to schedule more
gathering documents and things like that is tougher. Yeah.
But I guess I honestly I don't feel I have the answer for that. I could see it going both ways. I don't think it would be a dramatic swing one way or the other for the fee, but it could definitely have an impact on it.
So I want to give an opportunity to someone else here to ask a question because William's got some other good ones too. So Eric asks, if I prepare the SOFA and the schedules before filing but do not file them, then when the clients are filed and choose to continue with my representation, then I give them the schedules and the statements and file them, is that defensible? And there is an argument around that. It becomes a bit technical because basically what you have to say is the client doesn't get the benefit of the work you do until you give them that work. And if you don't give them that work and file it so that they get the value in their Chapter 7 case, that you haven't earned your fee. I would say the safer practice is to actually prepare the schedules post-petition versus doing it pre-petition. But as long as you understand your way around that argument and you wanted to take that approach, I mean, that there is an argument that you can make about that. I just think on the scale of safety and conservativeness with the court, that's going to be on the riskier side of things.
Yeah, well, the exception though, and we do see this, is that some attorneys still charge what I consider a really low fee in a Chapter 7. So, we know of attorneys who, even when they bifurcate a case, still only charge, $1,100 for the case. And so if you're doing that, there's not as much pressure to push work all into the post-petition timeframe. You can really do a lot more work pre-petition because the remaining work that has to happen still can justify that $1,100 fee. If you're charging $2,000 in a case, then I don't think you can prepare them beforehand. I think you really have to prepare them after the case is filed to make sure there's sufficient work to justify that post-petition fee.
Well, and understand too that while zero down is the method of doing this that really ends up having the most traction and really is taking over a lot of markets because it is the one that is most helpful to debtors and appeals to most debtors. The fact is that you can bifurcate the case differently. I mean, if you wanted to and you had a client that could afford to pay $500 or $600 up front plus the filing fee, you could afford to do the schedules pre-petition and just charge a more modest post-petition amount for the post-petition work. And that is completely consistent with what we're talking about because, again, the fees should reflect when and how you actually do the work and their reasonable value.
Yep.
So we have a number of people, Jane, William, I think there's one other attorney have asked about the filing fee. So Matt, you want to talk about the filing fee under our program?
Yeah, so you have a few options with the filing fee. And I guess the first thing to make really clear is that technically a filing fee is not due and cannot be paid until a case has been filed. So it is a post-petition expense that arises in a case. So since it's a post-petition expense, that means you can roll it into the financing, you can roll it into the payments your client's going to make for you or make to you. So for
that's if the attorney advances the filing fee, obviously.
Yeah, so you can still collect the filing fee like normal and pay it that way. But as in competitive markets, with a zero down, many, if not most or all attorneys don't collect anything and they get the case filed and then they charge a monthly payment or have the debtor make a monthly payment that includes all the post-petition work and the filing fee. Also, you can include the second class you have to take. Now, the first class debtors take, obviously that's pre-petition. You can't put that cost in. And the credit report too, you're going to pull the credit before you file the case. So those have to be either waived or paid up front. But in the filing fee, you can collect it up front. You can pay it later. You can file an application to pay the filing fee in installments. I think it's a needless complication in most cases. I have done that in my old cases when I was first bifurcating because I was just worried about the debtors coming back, signing the second agreement. Are they really going to pay me? do I want to risk $335 on this person? But what I found over time is they almost all come back. They almost all make their payments. And it was just a lot easier to just pay that filing fee when it was due, and not try to file an application for it to be paid installments. Because the other tricky thing is if you're to pay the filing fee in installments, the debtor cannot pay any money to the attorney post petition. So that would be
until the filing fee is paid.
Until the filing fee is paid in full. Yeah, sorry.
Yeah.
And so if it's a typical payment pattern or maybe 3 months for the filing fee, that means no attorney's fees can be collected until that's paid in full. So I really think the easiest and best way is just file the case, pay the filing fee, and include it in the amount that you're financing.
Yeah, so I want to actually expand on something Matt explained here, because we get a little familiar with the process, and some of you who are new to it may not pick up on this, but the scenario where you file the application to pay the filing fee in installments is one in which, the attorney goes ahead and advances the filing fee. They just wait until the debtor comes back in and signs the post-petition agreement before they're willing to advance the filing fee and bundle it up with the post-petition fees. And filing the application simply buys a little bit more time. So normally, if you go, it's either 3 or 5 days post-petition without paying the filing fee, the case is going to get administratively dismissed.
And they'll lock you out of ECF.
Yeah, and so if you want to meet with the debtor for the post-petition signing meeting and to review the schedules and statements and sign the post-petition engagement agreement, say 10 days later, some attorneys will file an application to pay the filing fee in installments. And then as soon as they have that post-petition meeting with the debtor, then they go ahead and they advance the filing fee out of their own ECF account and they bundle it up with the fee. And particularly if they're working with a company like ours, where we advance money on a line of credit to help you with cash flow, they go ahead and take their advance on the line of credit, which reimburses them for the filing fee and for a good chunk of their post-petition fees. And then we take over the payment management to, take that headache off of your plate.
Yeah, and if you are contemplating filing the motion to pay the filing fee in installments to get more time, do make sure you're fully aware of any local rules that require hearings on those. In a lot of places, there's not a hearing on them. There's effectively rubber stamped and approved, but there are districts where there will be a hearing on it. And it just creates a lot more work that I don't think is worth it.
Yeah. So we have a couple more questions, the gist of which is, how does Fresh Start funding fit into all this? And we really haven't talked about that because honestly, we didn't intend this to be a commercial. We really wanted this to be substantively helpful to you guys to understand how reasonability and Section 329 and the ethical rules factor into bifurcation. But Matt, maybe we could talk just a little bit about what we do and how we fit into the puzzle here.
Sure. So when you start collecting fees post-petition, you run into a few challenges. One is cash flow, because obviously you're not getting your money up front. And if you're doing what most people do, which is 12 months of payments, you're really spreading that money out over time. So you have a cash flow challenge. You also have a payment management challenge. We often use the example that if you're putting people, particularly on weekly payments, if you do 10 cases a month, by the end of the year, you have 120 cases, each doing weekly payments. You have well over 500 payments a month that you're managing. And as you know, probably from collecting payments from your clients, even before you file a case, there's lots of changes, lots of calls of, oh my gosh, you took the money last night, but I need it back. You're refunding money, you're changing payment plans. There's a lot that goes on with 500 payments. That's a lot of work.
It is. Well, and the simple fact is we've gotten some national statistics on this fairly recently that attorneys turn out not to be great at managing these kinds of things. And so across the country, the stats are that somewhere around 65 to 70% of the money is ever collected by the attorney in the first place. In other words, they have like a 30% or higher default rate. And in contrast, where we have technology, we have highly trained staff, we have economies of scale, and we have a unique approach that's a very friendly, constructive, let's keep you on track to that true fresh start kind of approach. We're collecting over 90% of the money across the country that's entrusted to our management. So we just get great results too that most attorneys can't achieve. And actually that ends up, when you look at it from that perspective, we end up paying for ourselves in terms of, the greater collection success that we enjoy.
And there's a couple of other things we provide too. Another one, which is really important, is we do credit reporting for the debtors. So once they start making payments to us. We report their payments to the credit bureaus, which helps them rebuild their credit. And where that really comes into play for the attorneys is when you're doing that initial consultation with your client, when you explain to them, if you do want to get filed right away and make payments, the other good thing I offer is that I'm going to help you rebuild credit. In fact, your attorney will be the first one to help you, get you back on your feet financially and getting your credit back. Because it really means a lot to people, and it really does help them improve their credit scores. So we do that, which is something attorneys can't do on their own. And then we also provide all the forms and training that you and your staff need to make sure you're doing everything legally and ethically. Because as many of you probably know, attorneys have gotten in trouble across the country when they do this wrong, and they always seem to do sort of the same things, wrong every time. And but we have all the forms, and like I said, the training isn't just for the attorneys. We have training for your staff too, and we're always available to answer any questions.
And then the last line of defense is that if you follow our program and you nonetheless get some unwanted attention from a trustee or from a judge, we actually will stand behind you. We have a defense guarantee and an indemnity. So we will respond to information requests on your behalf. We'll actually brief motions and respond to complaints if they get filed. Before the COVID days, I was literally jumping on a plane and going out and handling hearings for attorneys in our program when they would occasionally pop up. Now I'm doing it via video and telephone. And we'll also indemnify you. So if, there is a bad outcome, which candidly we've never had happen yet, but you were forced to disgorge some fees in a case and you had followed all of our guidelines and nonetheless gotten popped, we'll indemnify you up to $50,000 for that. Basically, the message is that we are very confident in the program that we have and in the legality and the ethical propriety of bifurcating and using a third-party financing source to help you, deal with the practical implications of bifurcation. And so we'll stand shoulder to shoulder with you, to defend you if questions are actually raised.
Yeah. So we're really running out of time. I don't know if we have any other questions we can answer quickly.
Well,
here.
Zoom is not being terribly cooperative with me right now, so I think we're probably going to have to call it a day. It looks like there may be a couple more recent questions that popped in. What I would encourage you to do, you're going to get a link to download the fee calculator, but you're also going to see contact information at the final slide here in the webinar. It's going to have a toll-free number and email addresses for Matt and I and so forth. And it sounds like an old infomercial, but I mean, literally there are folks standing by that can handle your call right now. If you have questions that haven't been answered, there'll be folks on the other end of the phone that can answer them for you. And Matt and I always say this, but we truly mean it. We're kind of big nerds about all this stuff. I'm probably a bigger nerd than Matt is, but we're happy to talk to you about these things because obviously as a new practice, to you potentially, and also a fairly new practice potentially in your district, you're going to want to make sure that you've had your questions answered thoroughly and you're comfortable with all this. And we've got the answers that should get you there. So we encourage you to take advantage of that. We also have what we call Fresh Start University, which is a portion of our website that is actually secured, but we can get you in there that you can see all of our articles that we've published, all the forms that we recommend to the attorneys, all kinds of resources that'll help you along. And one of the recent additions that's about to roll out too is that if you become a member of our program, we have a marketing and other resources page that's just fantastic. That's going to give you a lot of nuts and bolts information about how to market more effectively and drive more clients into your practice by using Zero Down. But there's also some just good general marketing advice in there that'll help all of you expand your practices. Because really this is about, doing well by doing good. The folks that participate in our programs often see their practices just multiply and fairly quickly because this is a solution that's desperately needed out there in the market. But we're not just about, attorneys making more money. We're about attorneys doing better by helping more people and relieving the burden on the system of pro se filers and folks that really would do better with an attorney's help. And that's why we talk about it being the win-win-win, and we're very serious about that. So,
yep.
Looking forward to answering any other questions that you have. Thank you for taking the time today to attend the webinar. Make sure that you get your download of the fee calculator tools and let us know how else we can help you along as you kind of decide for yourself whether this is something that you want to implement in your practice.
Thank you.